Hello, and thank you for joining us online today. Some of you may already have been on a previous talk that I've done previously, so welcome again. And if you're new, hello and welcome. So we're going to guide you through the main changes that are going to be brought in relation to the Renters' Rights Bill. If you'd like to ask any questions as you go, there is a question and answer option on the screen. So do type your questions and we'll see if we've got time to answer them at the end. We may not have time, but if not, then we'll try our best. So I'm Alice Harris. I'm a legal director in the property litigation team.
And I'm Ellie Mullins, and I'm a solicitor in the prop lit team here at Burkitt. I work alongside Alice on all residential matters.
So Ellie and I both specialise in residential landlord and tenant matters from the start. We're drafting tenancy agreements and getting tenants in the property, and also through to the end where we deal with eviction. So we can deal with everything that happens in between as well. We will refer to the Renters' Rights Bill as we go through, which is the new Labour government's bill, but we might also mention about the Renters' Reform Bill, which was the Conservatives' attempt to bring in changes to the private rented sector. So they're the two things that we will be talking about today, but focusing on the Renters' Rights Bill. So the Renters' Rights Bill is delivering Labour's manifesto to transform the experience of the private renting. It seeks to bring in drastic changes to the private rented market, which have been threatened for many years. The Conservatives did attempt this, first mentioning it in 2019, but still didn't manage to get it over the line. Labour are pushing this quickly and swiftly, and they really want to bring it in as soon as they can, and they've made that very clear. They think the changes are needed because the private renter sector has doubled in size since 2002, and there are approximately 11 million private renters out there, which equates to 19% of the housing market. And according to Angela Rayner, the Deputy Prime Minister and Secretary for State and Housing, since 2019, there has been more than 100,000 houses facing no-fault evictions, which is under the 21 notice procedure. And 26,000 of those have been in the last year. And they feel that they want to bring the bill in to give tenants greater security and level the playing field. So this slide sets out the main parts of the bill, or the headlines, the bits that I think are going to impact landlords and agents the most, or be at least concerned about at this time. There's a lot to cover, so it is going to be a bit of a whistle-stop tour with the main highlights. The bill does go further than the precursor reform bill that I mentioned earlier, because it includes the decent home standards, discrimination, greater enforcement powers, and some other changes that the reform bill didn't bring in. So we will guide you through those. The majority of the bill relates to English law. However, there are some in there that relate to Wales and Scotland, but we won't cover those today. We're just going to focus on the changes to England. And the one thing landlords and agents need to be aware of is that once the bill has been introduced, it will be the new regime and parties cannot contract out of the bill. It will come into force, and if it's applicable to your tenancy or the tenancy in question, that's it. You've got to like it and lump it, and you've got to deal with it, which is why we think it's important. There are some elements in the legislation that we won't be able to cover today because they could be subject to their own talks, which are social housing, purpose-built student accommodation, and agricultural tenancies. They can be subjects all on their own. So we're just focusing on the other elements at the moment. But I will say that there is an exemption in the new regime for purpose-built student accommodation, as long as the provider is registered for a government-approved code. So it's not going to be the normal private student housing that deals with. But one glaring, I wouldn't say error, but omission from the bill that we can see is that the bill does not cover the court reforms. As most of you will know, and anyone in the profession will know, that the court system for possession claims is in disarray. There are severe backlogs and it can't cope at the moment. So what we're not quite sure of is how far this bill is going to push it and how it's going to cope with the new changes that come in. Michael Gove, the former Housing Secretary, had previously said that he was going to introduce the changes on the court system before the changes came in, but nothing's been said about this in the new bill. They're just going to go ahead. There's been mention in the second reading of digitising the court process, which sounds great, but how that's going to be brought in and when we're going to finally see benefits to landlords because of a speedier system, we really don't know. So I think the changes are coming. but how well they will be introduced is another thing to see, and how the courts will deal with it. So right, you might be thinking, why should I take note of the new regime now? Well, now is the time to start getting ready. This is coming in. Labour are bringing it in quickly. They're talking about spring 2025, could be earlier. So we just need to be aware. Now's the time to take stock of your property portfolio and assess whether the new regime, it works for you, whether you want to get out of the market, whether you want to stay in it, and what changes you need to make. And if you do want to remove tenants who you might not want in long term, now's the time to do that. And also for agents, now is your time to assess your working practices, overhaul your processes, documentation, trainings, so you can be compliant from day one and not at risk of breaching the new offences that come in. So you just got to get ready. It's coming. You can't avoid it. So let's just get it sorted. And we're here to give you this webinar to kickstart your analysis of your portfolio, your assessment, and we can help you. And I just want to emphasise that. We deal with this, we've looked into it, we are researching it, we're keeping on top of it, and that is to save you from doing so we can advise you and help you through the processes. So that's kind of like the introduction, and now let's dive into what we would call probably the interesting bit, but for you guys, probably not so interesting if you're not a fan of legislation like we are. So we'll dive into the first clause of the bill, which is clause 1 in relation to the removal of fixed term tenancies. This is the headline, which you'll all be aware of. All tenancies will become assured periodic tenancies. So any tenancy that is currently covered by the Housing Act 1988 will become a periodic. You will no longer be able to do fixed terms. Fixed terms will not work. And if you try, it's actually committing an offence. If you seek to grant a fixed term, you're committing an offence and you can be subject to enforcement action. But any tenancy that doesn't fall under the Housing Act 1988 falls outside of the new regime. So things like company lets to companies, or rents which are really low or there's no rent, or high rents. All those tenancies, if they're outside of the AST scheme at the moment, then the chances are they'll also be outside of the new regime. So that might be something worth considering, mixing up how you do things, whether company lets are better for you and the way you do it. So it's just something that you might be able to get around it. For the majority of tenancies, you won't, but there will be certain scenarios that we can consider for you to see how you can avoid it. The aim of periodic tenancies is to give tenants more flexibility. Tenants are allowed to stay longer if they want, but also end tenancies when they want, which Ellie will come on to shortly. And that might help tenants where they're in poor conditions or the landlord is not meeting their obligations. Any clause that seeks to put in a fixed term into a tenancy agreement will no longer have effect. And all rental periods must either be monthly or less than 28 days. And so there's a big question mark at the moment over being able to charge advance rent. In the bill, it doesn't cover it, doesn't allow it. But in the second reading, the Deputy Prime Minister was questioned on this, and she said it's something that they're keeping an eye on. So I think they're very conscious that people want to be able to charge advance rent, especially if they're unsure of the term or if it's going to be a long one. So that might be changing in the offing. There's also clauses in there which talk about the effect of superior leases, and all references in superior leases which are required to have, which would be assured tenant ASTs, will no longer be in effect. So you can't say, well, I've got to grant an AST because my superior lease tells me I need one, because actually that clause in the superior lease will be ineffective and no longer apply. Also, leaseholders with long leases over 21 years will not be under an obligation to provide vacant possession if they sublet under an assured periodic tenancy. But there is a new possession ground that if your long lease is coming to an end and you need to get vacant and you want vacant possession, there is a ground upon which you can rely upon. There is a 7-year out carve out. So tenancies up to 7 years are all going to be caught by the Act. But if you've got an 8-year tenancy, that will come outside of the Act. So again, it's a mechanism that you might want to consider the length of your tenancies if you want to take it outside the Act, granting them at 8 years, 7 years or more. So that's something we can consider. And there's no transition period. This will come in from the date of the commencement of the bill, and all tenancies will be caught, whether they're new, existing, everything will be caught. And Labour wanted to avoid a transition where you had some starting from new and some starting from the existing 6 months later, which was what was suggested by the Conservatives. But Labour have said they don't want the dual system, just one date where it's enforceable and everybody knows for clarity and to avoid confusion. They want it to come in on from one date. Whether that's the date of the bill or whether it's going to come in slightly after the bill, we're yet to see. So as to when, it's not entirely sure, but we know it's coming in one foul swoop.
Yeah, I will now discuss abolishment of Section 21 notices. So one of the major changes, which I'm sure you're all aware of, is that the bill will abolish Section 21 notices. This causes a major concern for landlords, as landlords will essentially no longer be able to evict a tenant for no reason. So under the current law as it stands, Section 21 notices give landlords flexibility to remove tenants upon service of a 2-month notice without any reason whatsoever. However, under the new law, landlords must have a reason to evict a tenant, which Alice will discuss later on in detail. Labour proposed to introduce this in one stage, as Alice just mentioned. So when the bill becomes law, no one will be able to serve a Section 21. This is different, as Alice said. So under the Conservatives' proposals, they said a 2-tier system, which was going to be confusing for everyone. So I'm glad that Labour have changed that. In my experience, and I'm sure Alice will agree, in practice, Section 21 is definitely the most commonly used eviction process. Over the years, the process has been subject to a great deal of change to make it harder for landlords to rely on Section 21 notices. So, for example, you've got the requirements of gas safety certificates, deposit requirements, EPCs, how to rent guides, etc., as well as all the case law around that. So it does make it tricky. But yeah, Labour have now gone the whole way and essentially removed it completely as an option. So under the new law, landlords can now only evict a tenant using the Section 8 notice process, which means that a landlord has limited grounds to essentially evict a tenant. And these Section 8 grounds have been modified and added to under the new law. You may ask why the government have decided to abolish Section 21, and there is kind of loads out there, so I'm sure you guys are all aware, but essentially this levels the playing field between landlords and tenants. So it's empowering tenants to challenge poor practices and unjustified rent increases, as well as incentivising landlords to engage and actually resolve issues. So hopefully we see a difference. Again, we will have some time to serve any Section 21 notices prior to the bill coming in, but me and Alice have discussed this, and we do expect to see quite a surge in Section 21 notices being served before the bill reaches its final stages. So I would suggest that kind of if you're thinking about it, selling, wanting vacant possession, do get in touch and start thinking about that now before next year. Again, me and Alice are already reviewing tenancies and documents for landlords and agents to ensure that a valid Section 21 can be served as soon as required. So yeah. I also will touch upon tenants' notice to terminate the tenancy. So again, under clauses 19 and 20, which you can see on the screen, will govern kind of when a tenant can serve notice. Tenants must now give 2 months' notice under the new law, as opposed to 1 month on the landlord to end their tenancy, unless, of course, if the landlord and tenant have agreed to a shorter period in writing prior, then that's fine. The period of notice required is not less than 2 months before the end of a period of the tenancy. So, for example, if the tenancy commenced on the 8th of the month, the notice must expire on the 7th of the month, at least 2 months later. It is important to note the following. So landlords cannot specify a particular form of written communication. This essentially gives tenants more control over the process on how they terminate the tenancy. Again, leading into kind of what Alice said about tenants having more flexibility. And it's also important to note that the notice can be withdrawn before the expiry date if agreed in writing by both parties. So yeah, although this gives tenants more flexibility, this does have implications on the landlord, because a tenant can essentially take a property on and then just give 2 months notice to vacate. So that this then leaves the question open as to whether tenants can use properties as kind of holiday lets, as we discussed. So say, down in Cornwall, for example, in the summer it's lovely. What's stopping a tenant from kind of entering into a tenancy, which is periodic, and then given 2 months to vacate? So it doesn't really give a landlord a guaranteed stream of income as opposed to a fixed term tenancy under the current law. So we're yet to see kind of what happens. again, kind of me and Alice have discussed this, but with the introduction of the tenant's ability to terminate for no reason. So a tenant doesn't have to have a reason to terminate a tenancy, but under the new law, a landlord does. So it's a complete kind of power switch, which me and Alice find kind of confusing and kind of why should the tenant be able to not have a reason, but the landlord does? So we'll see.
Yeah, it's interesting that a landlord used to have to be able to get away with giving notice without giving any form of reason, but they've now stripped a landlord of doing that, but then given a tenant the ability to do it. So it's just a complete switch, which is interesting, and will be interesting to see how landlords feel about that. That might be it might not sit right to begin with, but we'll see how it goes on. So the main grounds, now you can only get tenants out under a Section 8 notice. I will take you through these grounds. There's quite a lot of new grounds. Some of them are for social housing, landlords or agriculture, which we won't cover today, so I'll kind of gloss over those, but they're all on the screen of the notices that have been changed. So where there's a change on my slides, I've done it in red. And where there is a brand new ground, they're highlighted in like a purple colour. So you can see clearly on the slide, if a change has been made, it's red and a brand new ground has come in. I've also stated if they're mandatory or discretionary grounds, because that's quite important to know. Mandatory grounds are preferred. They're the better ones to use because if you satisfy the criteria, the court must order possession. Whereas discretionary grounds, you've got to persuade the court to use their discretion to give you possession. And as we will say later on, courts are finding every reason to use their discretion to not grant possession at the moment, and I don't see that changing drastically. So if you can go on a mandatory ground, you can also rely on several grounds in one go if you need to. The more grounds you put in, the more one of them might hit home with a judge, but the mandatory ones are the better if you can use it. And one thing that's also quite interesting about this bill is they've removed Section 21 notices, which are the no fault eviction grounds, but there are some grounds in Section 8 which are no fault. So the landlord wants to move back in, which is at no fault of the tenant, or the landlord wants to redevelop, that's no fault of the tenant. So any Section 8 ground that is a no fault ground, they've increased the notice period to 4 months. So not only have they removed the ability for you to give the 2 months under Section 21, they've also increased the notice period, or they've doubled it, for the no fault grounds under Section 8. So again, giving tenants longer and more security because notice periods have to be longer. So we'll dive straight into ground 1, which is the occupation by the landlord, and now the landlord's family. So it covers a wider category of people. Parents, grandparents, siblings, children and grandchildren are also included, not only for the landlord, but for the landlord's spouse as well. So that's a bit of a bigger category who you can say you want to move into your property in order to be able to rely on this ground. And it also includes half-blood relationships, so stepchildren and things like that. There's no need for advance notice to be given at the beginning that this ground is going to be relied upon, which is good because you might not know you need to rely on it at the beginning. You don't know what family situation changes. But one thing you can't do is you can't use this ground in the first 12 months of a new tenancy. So you will have to wait. You do have to wait that 12 months minimum period for a new tenancy before you can say, well, I want to move in, or my child wants to move in, or my brother or sister wants to move in. And one thing that is coming in is also, if you rely on this ground and you say my sister wants to move into the property and you serve a notice on the basis of it, if the tenant then vacates, you can't then re-let the property if the letting to the brother or sister doesn't go off for a further 12 months. The reason they've brought this in is they have tried to make it sure that landlords are not saying, oh, well, my wife's son is going to live in the property, and so I need you out, but with no intention of the wife's son moving in. So they're trying to stop abuse of the grounds. And if you misuse the grounds and re-let after the tenants have moved out, you can be subject to a fine of between £7,000 and £40,000. So it's quite a big penalty. So it's really trying to make sure landlords use these grounds correctly and not abuse them and just throw them out there to try and get the tenants out. And also, this enforcement by abusing grounds is brought in by the local authority. They're the ones with the ability to fine and take action. But that's relying on tenants basically reporting on the landlords, because local authorities are not going to keep an eye on every single property why notice was served. So it's relying on tenants to go to the local authority and say, my landlord told me they wanted to move out, but they didn't. And well, they moved out because a family member's moving in, but they never did it. And so I moved out and I'm aggrieved by this. And so it's relying on tenants reporting it. So one thing the government have done is given an incentive for tenants to do this, because they've now widened the scope of something called rent repayment orders, which I'll talk about later, to make them more available for more offences. So a tenant has got basically an incentive, in my opinion, to go to the local authority and keep an eye on what a landlord has done, even if the tenant has already moved out. But there'll be more on that later. There's also a new ground 1A, which is in relation to the sale of a property. A lot of landlords are worried about this. What if we want to sell? Well, good, because there's now a ground to cover you. However, again, it can't be used for the first 12 months of a tenancy. And one thing that's interesting in the bill is there's no mention of what evidence you need to say what you're going to do to sell the property, whether it just needs to be put on listed by an estate agent. Do you need to get to exchange of contracts? There's no indication there as to what is needed to show an intention to sell, or is it just a thought or just a valuation? So it'll be interesting to see if any further clarification is added as they discuss it in the House. But one thing they will do is it will also include sale and transfers of property. So sale as well as transfers. If you're transferring the property for various reasons, it will also cover that as well as a sale. But again, it's got the enforcement teeth there that you can't relet the property for a 12-month period after you've relied on that ground. So if for some reason you say, I'm going to sell the property, the tenant moves out, but you don't sell the property because either you can't sell it, then you have to wait 12 months unless that letting is to a prospective purchaser. So if your buyer wants to move in on license before you complete, you're allowed to let it to them. But again, all of this is relying on tenants reporting abusive use of the grounds to local authorities, and we might see more tenants helping police the use of these grounds more than what we see now, which is going to happen. So there's another ground, which is ground 1B, which relates to social housing landlords under a right rent to buy scheme, but I won't go into that in detail. And then the ground 2, which is sale by mortgagee, it's had some amendments made. It's removed the requirement for the mortgage to be in place prior to the tenancy, because at the moment, if you're relying on that ground, your mortgage has to have predated the tenancy. Whereas under the new regime and the new ground, that mortgage, it doesn't matter when it comes into play. If it's already there and in situ, or it's in during the middle of the tenancy, they can seek to rely on this ground, but they have extended the notice period from 2 months to 4 months. So let me just find that. So these are all grounds in relation to superior leases, where there are certain obligations in which to remove a tenant due to a superior lease. Grounds 2ZA and 2ZC, very strange numbering, but that's what they've gone with, can be used for social housing landlords only. So I won't cover those today, but they are there. The new ground 2ZB is for private landlords subject to a superior lease, enabling them to terminate a tenancy where the superior lease is coming to an end. So this is something that wasn't in the Renters' Rights Bill, and I think because it was, Reform Bill, it was debated in the House, so I think they've added this in to try and avoid that controversy. And also ground 2ZD, which is a new ground to assist superior landlords who have found themselves what I would term as accidental landlords, where the long lease has expired or the intermediary lease is gone, and they can then deal with the tenants themselves as superior landlords who have actually stepped into the shoes of their periodic tenancy landlord, but they can only be used for long leases, those ones. Holiday lets, that ground 3 has been removed, completely gone, which is quite interesting, given that they are now potentially allowing tenants to serve notice. Well, they are allowing tenants to serve notice as soon as they move in. They can move in and the next day give notice to move out again in 2 months, which presents potentially what we would normally see in a holiday let. So that's quite interesting. Ground 4 is student accommodation, but this relates purely to the purpose-built student accommodation, like university halls and things. So it doesn't cover private student houses. But those of you that deal with student properties will be pleased to know that they've introduced ground 4A, which relates to properties housed for rented for students, and they needed for occupation for a new student. So that's good, but there is certain criteria in order to satisfy that and use that ground. It must be an HMO, the property, So that unfortunately means that any properties let to students which are 1 bed, 2 bed, smaller properties, you won't be able to rely on this ground. So that might be something that you need to consider if you're in this remit. And also the student test must be met when the tenancy is entered into. And that means that a landlord can it can be a current student or someone the landlord reasonably believes will be a student when the letting is on. So that helps those students who have to arrange the accommodation before they're enrolled, before they get their results. So as long as the landlord reasonably believes they will become a student, they meet the student test. But every occupier in that property must meet that student test at the time the tenancy commenced. So what you should try and avoid doing there is letting to potentially students and other parties who might be friends but workers, and so it's a combined property, because all of them must meet the student criteria. And also, interestingly, you can only rely on this ground to expire if you serve a notice on it between the periods of 1st of June and the 30th of September. And because the notice period you have to give is 4 months, you have to be really quite precise in your timings and serve it before the 1st of June, potentially before you know where there's going to be an issue with them refusing to get out. So I think we'll find quite a lot of prospective protective application Section 8 notices served on this ground in order to make the use of the 4-month tenancy to fall within that very small window of opportunity to get them out. So that's something you need to be aware of. You need to plan ahead with those months. And also you need to tell the tenants at the beginning in the statement of terms that they meet the student test and that you can rely on this ground. So advance notice needs to be given in relation to those ones. And ground 5 about ministers of religion remains the same, apart from the fact you just have to give advance notice in the statement of terms. And when we talk about statement of terms, it's basically the tenancy agreement, but we'll cover that more as we go on. So we've got some grounds here, new grounds in relation to agricultural workers, and also one in relation to who needs the occupation needed for employment requirements, but that's for social housing landlords. So the details are on the slide, but I'm not going to go into too much detail on that one. And again, more ones about employment. So the new ground 5C is an employee linked ground, which will assist landlords who let properties to employees. It was previously ground 16. So it's jumped up in priority in the list and become a mandatory ground now, which is great. But advance notice must be given if you're going to rely on that ground. And ground 5D applies to social landlords. So we won't cover that today. And then the ground 5E and ground 5F relate to supported accommodation. So there's some options there for landlords who deal with supported accommodation. And then we've got new grounds in relation to homelessness and stepping stone accommodation, which some of you out there might be dabbling with. And then ground 6. So this is again a new non-fault ground. Sorry, not new, it's a no-fault ground. So if it's not the tenant's fault you want to redevelop and it's mandatory. But the notice period has again been extended from 2 months to 4 months. But it's not clear again what evidence you need to show that you as a landlord need to redevelop. It doesn't make it clear whether plans, costings, budgets, loans, or whether you need planning permission. It's just not clear, and it's a bit akin to the Landlord and Tenant Act 1954 requirements. I think you just need to show the genuine intention, and that will depend on the circumstances at the time. So it'll be interesting to see if they add clarification as to what's needed and what would actually satisfy that ground as this gets on. And also it's open to a bit more abuse. If it's a bit more interpretational as to what your intention means, then you might find landlords are trying to shoehorn in grounds, shoehorn in works that might not actually fit under this ground as needing the tenant to actually completely move out of the property in order to do the works. But again, that's relying on tenants reporting to the local authority where landlords may have abused this ground, really. But again, everything to do with rent repayment orders, which we'll talk about later. And one thing you need to be aware of is you can't use this ground for the first 6 months of a new tenancy. So you just need to be aware that you have to wait a little bit. You could probably still start making your intentions and applying for any planning permissions that you need, but you can't then serve the notice in the first 6 months. And then you need a 4-month notice period. So you just need to factor that in. So minimum 6 months term if you're then going to seek to redevelop. So then we've got some more grounds. New ground 6A, which deals with a landlord's needing possession in relation to remedying breaches such as HMO licenses refused or revoked, banning orders. So we've had it before where landlords have said we've got to get possession because we're in breach and the local authority require us to. But this ground now gives them the hook they need to get the tenants out on the basis of the fact that they need to, they're being forced to, in actions being taken against them. So that should be quite welcome for some people. Obviously, not the fact they've got into the situation in the first place, but if they find themselves there, they have got this ground to rely upon. And then ground 7, death of a tenant, remains exactly the same, but it remains unchanged. And now we've got ground 7A, the serious antisocial behaviour ground. This is where you rely on it, where a conviction has been occurred or an offence has been committed. But you can now commence proceedings immediately. You have to give notice, but you can commence proceedings as soon as that notice is served, which is good and great. But then the Act goes on to say, but no possession order must be given within 14 days of the notice, which sounds wonderful, but I'm yet to find a court that I would reliably say would be able to deal with your application, get you a hearing, and get you a possession order in any time less than 14 days. So it's good that you can do it and you can do it immediately. And I get why they're putting the boundary in there to say 14 days. But if you can manage to get it anywhere close to 14 days, you'll be doing incredibly well, especially with the new changes coming in. So that's that one. So you don't need to give any notice. Ground 8, this is the ground that we find is most commonly used at the moment. It's basically for rent arrears, and you normally couple it with 10 and 11 grounds, which are the discretionary grounds. So anything to do with rent arrears is normally 8, 10 and 11. You claim them together. Interestingly, the length of the notice period has gone up from 2 weeks to 4 weeks. So you have to give that 4 weeks notice, which automatically puts them behind, if they're already in arrears, another month. But also the threshold for those rent arrears has been changed from 2 months to now 3 months, which is quite drastic because you're already relying on the tenant being in 2 months worth of arrears and going on a 2-week notice period. And it's now shifting to say they need to be 3 months in arrears and relying on a 4-week notice period. So potentially you're already 4 months in rent arrears before you can issue court proceedings, which is quite substantial. So that's something landlords need to be aware of and try and get a tackle on rent arrears and keeping on to the tenants and see if they can encourage payment earlier where possible, and be aware that you might need a buffer of at least 4 months if you find yourself in this regime. And also you can't count universal credit into the arrears calculation if it's going to be paid at the end of the month. There were proposals under the Renters Reform Bill for a new ground which would catch those renters who keep dipping into rent arrears and topping it up just to the less than 2 months worth of rent arrears to prevent ground 8 from being used, but that hasn't made an appearance at all in this bill, and I don't think it will. It might be introduced later on, but because it's not in the initial draft, I think that they've deliberately scrapped it and want to keep it at 3 months worth of rent arrears to be able to rely on this mandatory ground. So now we're in the discretionary grounds. This is in relation to ground 10 and 11 in relation to rent arrears, which we normally use with ground 8. The only thing that's changed in relation to that is it's a 4-week notice period now instead of a 2-week. So it's again just delaying that time a landlord can take to get action, potentially giving more time in which for the tenant to be able to pay. But in some scenarios, if the tenant can't pay, they're already not going to be able to pay, and you're just accruing further arrears the longer you can do. And you've got ground 14, which is the antisocial behaviour discretionary ground, where there's been no formal conviction of a person. And the difference here is, again, you can do it immediately after you've served a notice. And again, no possession within 14 days. But if you can get anywhere close to 14 days, you're doing really well. But court now, there is a clause been added in where the courts have to take into account certain information in relation to this ground. And those two that I think are important are whether the tenant has engaged with the landlord to try and resolve that behaviour. So the landlord can't just serve a notice and say, I want them out on this ground, because they'll then have to justify to the court why they haven't tried to engage with the tenant. Have they tried to talk to the tenant, alter their behaviour? So just be aware, if you're seeking to rely on this ground, you might need to be a bit more conciliatory with the tenant and try and see. And if the tenant fails to engage, that will obviously assist the landlord's case. And then the other one is where there's a HMO, the court has to consider the behaviour of that problem tenant to those in the other HMO, because what the court wants to be conscious of is just because you can't remove one tenant, you might lose the 4 other tenants because of the difficulties they've been dealing with. So that's a good point. So the court can take all that lot into account. So they were the grounds that had kind of been changed or amended or new grounds. And then I've set out on that slide for you to read at your leisure. The rest of the Section 8 grounds, which are not changed, they stay the same, everything's fine, the notice periods have all stayed the same. So they are Section 8 grounds, and clause 6 of the bill is talking about the Secretary of State being able to introduce a new prescribed form. And I have no doubt that there will be a new form that we have to all use for Section 8 notices prior to the legislation coming in. There's one in place at the moment, but I've got a feeling they're going to update it. It's going to be a new one, and that's what everyone will have to use going forward. So now you know what grounds you can rely upon. You need to know what you need to do to be able to use those grounds. So say, for example, in Section 21 proceedings at the moment, you have to tick all the boxes to do with rent repayment, or to do with right to rent guides, EPC, gas safety and deposit. There are certain requirements you need for a Section 8 notice, but they're not the same. So I'll just go through these now. So one of them is that you have to comply with the deposit requirements. And this is where it gets a little bit vague, on the sense of, they say you must register the deposit with the scheme, you must comply with the deposit's initial requirements, and you must provide the prescribed information. Those two latter requirements can be done at any time, but what is not entirely clear is in relation to the registering the deposit, and whether they potentially will now accept late registration. So we're just waiting to see how that is interpreted and how it goes forward. But if you can't comply with those things, they do have the option to return the deposit or agree deductions. But Ellie and I have both had cases, and I'm sure many of you might be aware of it, is where tenants are refusing to take back the deposit because they know they can then be served with a Section 21 at the moment. And so if they think they can prolong service of a Section 8, they potentially might be able to hold the landlord at ransom again, which I really hope that the government address that point before it goes through.
Yeah.
Because right now we've got landlords who can't do anything with Section 821 notices because the deposit can't be returned, because the tenant is refusing cash, refusing deposit, and refusing to give bank details just because they know they can put a kibosh on a Section 21. So we just need to be cautious, and we'll keep an eye on that and provide an update once we know. And then the second requirement is that you must register with the new private rented database. And I'll have more on that later, but they're the two requirements. But interestingly, the government have stated that those two requirements must only be complied with before possession can be given. So before a court can award you possession, you have to have ticked those boxes. But what it doesn't say is that you have to do it before you serve a Section 8. So it's potentially that you can front load your notices, front load getting through the procedure and applying to court, and then deal with everything before you actually get to the hearing. We wouldn't advise that. We would always advise making sure you can do it right from the start before you serve a Section 21. But the option is there that potentially you might be able to sort out and remedy after you've issued the notice. Whereas right now, if you haven't done it before you serve a Section 21, you can't serve a valid one. So that's the difference. It's a shift on focus as to when compliance needs to be done with, not prior the notice, but after the notice. So that must be quite interesting. So I think that's all. And then also where advance notice grounds have to be given, which I've talked about before, where you have to give advance notice of relying on them. A court can still give possession even if you didn't give the advance notice, but you can still be subject to a financial penalty from the local authority for relying on a ground where you didn't give the advance notice. So that's something to be aware of. And again, fines for failing to comply with these things are coming through between £7,000 and £40,000. According to the legislation. And so, for example, if you say my child is going to move into the property, I need it back, I'm going to serve a ground under ground 1, serve a Section 8 under ground 1, and my daughter's going to move in, and then the tenant moves out. If they move out within 4 months of that notice and your daughter never moves in, and you wait the 12 months before you can relet, and then you relet, the tenant can still report you to the local authority, and you can be subject to a fine of up to £7,000 for
saying you're relying on ground when you have no intention of doing so. So it's really honing in on a landlord's ability to use these grounds correctly, and so they can actually know they can't use them recklessly. They have to know that they would be able to satisfy the grounds when they serve them. So just be aware of that. No more serving them and just see what happens.
Yeah.
Because then unfortunately the see what happens might actually result in a fine for the landlord. So we just need to be aware of that.
Yeah, I'll now discuss rent increases, which, as you can see, is clause 7 and 8. So essentially, under the new law, the only way to increase the rent will be by way of a Section 13 rent increase. So under the current law, a landlord is only required to give 1 month's notice with a Section 13 rent increase, but this will now change to 2 months' notice. Essentially, the aim of this is to stop retaliatory rent increases being used as a route to evict tenants. So, for example, under the current law, a landlord could increase the rent by giving 1 month's notice, knowing kind of full well the tenant can't afford that rent. And then the landlord can then use this to evict the tenant, either by Section 21 or Section 8, if they fall into rent arrears. So this new law is essentially stopping this from happening. Also, so when under the new law, the new rent will take effect 2 months after service of the Section 13 notice. If it isn't challenged in the tribunal, or if a landlord and tenant agree a different rent or no increase at all. So it is open to the parties to agree a new rent once the Section 13 notice has been served, or after a tribunal determines the outcome. Both parties can only agree a rent that is lower than what is set out in the Section 13 notice or the determination of the tribunal. So again, it's protecting the tenant from kind of high rents. What me and Alice find interesting is that tenants can now challenge rent in the first 6 months of the tenancy, which is quite unusual. So under the current law, a tenant will take on the tenancy for the fixed term. They'll know exactly what the rent is going to be charged because it's in the tenancy agreement. However, now a tenant can essentially take on a tenancy and then challenge the tenancy. So landlords really do need to be aware of this, and it's quite unusual. So yeah, they can challenge this from the moment they take on the tenancy. Again, giving kind of flexibility to the tenant, there is no prescribed form that needs to be used when a tenant make an application to the first tier tribunal. So again, it's making it more tenant friendly, easier for tenants to challenge rent where they don't feel like it's fair. So the first tier tribunal can backdate the rent decrease to the date of the application, where the challenge is made in the first 6 months of the tenancy. So where the challenge is made after the Section 13 notice, the new rent will take effect from the date of the determination or the start of the next rent period if it's different. However, if a tribunal feel an increase would cause undue hardship to the tenant, it can actually delay the rent increase for a maximum of 2 months from the date of the determination. So again, giving tenants more flexibility, more ease. Me and Alice have discussed this, and we do think that rents could increase as the market shrinks, because I know I've spoken to a lot of clients and they're saying I don't want to be part of this when the bill comes in. So yeah, we do think the market will shrink. And these kind of restrictions on rent increases may lead landlords to actually charge kind of higher rent from the start. And then kind of as discussed, rent can be challenged by tenants within the first 6 months. So potentially me and Alice both think that actually landlords may kind of charge the higher rent as much as they can and then be brought down, because tenants can now challenge it. So it can only be brought lower rather than higher. So it'd be interesting to see. A new clause has also been introduced to prevent rental bidding. So agents and landlords are actually required to publish an asking rent for their property, and they will not be allowed to ask, encourage or accept a higher offer. So again, protecting tenants. So this, however, could prompt higher rents to be stated by landlords to see if the tenants are kind of willing to bid up to the asking rent. So yeah, we'll see how it plays out. Yeah, so I'll now discuss pets, which is clause 10 and 11. So since COVID, pets are on the rise, so especially in the private rented sector. So there's definitely been an increase in tenants wanting to keep pets. So under the current law as it stands, landlords don't have to accept pets. Landlords can say, I don't want pets in my property, and they can put a clause in the tenancy agreement which states tenants aren't allowed to keep pets. Which suits some landlords because they don't want kind of mess and stuff in their properties. But under the new law, landlords can't unreasonably refuse a tenant to keep a pet. So you can no longer kind of have a clause in there which says, absolutely put an absolute ban on tenants keeping pets. So if a tenant does request a pet, a landlord must respond to that request within 28 days. So it's really important that, as landlords, if a tenant does request a pet, you don't kind of just ignore it. You do have to kind of respond within the 28 days. The only time a landlord can actually refuse a pet is where acceptance of that pet would breach kind of a superior lease. So that's kind of when you can say no. So again, me and Alice have discussed this, and there is kind of room for potential abuse. So if a landlord really doesn't want the tenant to have a pet, there's kind of nothing stopping a landlord from, seeking to use kind of the 28-day period to potentially find new tenants, etc., who don't have pets. So if a landlord really doesn't want tenants who have pets, it's open for the landlord to inquire and make sure that your tenants don't want pets firstly. But again, you can't stop that. So if you've got a tenant and they want a pet, you can't unreasonably refuse. So what is kind of difficult to know, it's unclear because it's all kind of new under the new law. It's unclear what would constitute kind of unreasonably withholding consent. So it does need further clarification, which hopefully will be published when the bill's published and be debated further. But we do know that kind of elements such as size of the proposed pet and size of the property will be key considerations for a landlord to take into account. In the second reading, which was last week, Angela Rayner did state that the landlord's ability to refuse consent is all about reasonableness and refers to an antisocial parrot that sleeps all night. So again, whether this would cause a nuisance to other people in the property or neighbours are all key considerations, which I think is fair. It's also important to note actually that clause 11 amends the Tenant Fees Act 2019, so it makes pet insurance a permitted payment. This means that landlords can, if they accept the pet, then landlords can actually charge a reasonable cost incurred in relation to pet insurance, or they can require tenants to obtain suitable pet insurance. So again, although landlords can't now unreasonably refuse, the government have kind of thought, oh well, there must be something in place, so pet insurance to protect landlords if there is mess, etc. So yeah. I think Alice actually mentioned this earlier, but essentially statement of terms and information. So this places a duty on landlords to provide a tenant with a written statement of terms and information before the start of the tenancy. So it will no longer be acceptable to have an oral tenancy, which we think is a really good thing. There's always kind of confusion and room for kind of interpretation when there's an oral tenancy. So written, it's kind of a bit clearer. Landlords must state in the written statement of terms where they may wish to use any of the prior notice grounds, which are on the screen. I won't repeat, but Alice has gone through them. It also allows the Secretary of State to make regulations to require which terms and information are required at the start of any tenancy. So when the bill is published, we'll have kind of clearer indication of what actually needs to be included.
So now we move on to discrimination, which is a new element of the bill, which doesn't feature in the Housing Act at the moment and wasn't in the reform bill, although it was talked about, is prevention of discrimination against tenants in relation to children, families, and being in receipt of benefits. So what they're seeking to do is prevent landlords from being discriminatory for any of those reasons, saying a blanket ban of no families, no children will no longer be allowed, and a blanket ban of no tenants on benefits will again no longer be allowed. An enforcement action can be taken against landlords if they breach, and agents who breach this offence. So you must consider where the instructions are coming from. If agents are receiving instructions from landlords to put adverts out saying no children, agents need to also be aware that they need to report to the landlords to say, well, actually, that's not acceptable anymore. So it's just something for both agents and landlords to be aware of.
There are exemptions, one of which is if the conduct is a proportionate means of achieving a legitimate aim. So a very legal speak there, but it's essentially, I'll give you an example. If the letting is for a single room in an HMO and the tenant is a lady who says she's going to move in with her 2 teenage children, well, the room is not suitable for the 2 teenage children and cannot be let legally to those 3 in one property. So you could say that actually you can refuse consent on the basis that she's not allowed to let because she can't legally let the room to that many number of people. So it wouldn't be based on the fact of the children, but the basis of the letting would allow you to do that. And there's also an exemption that if the conduct is done to fulfill a condition of an existing insurance contract, and I'll deal with that shortly. Any terms of a tenancy or superior lease or mortgage terms cannot seek to restrict a tenancy relating to children or those on benefits. And that has retrospective effects. So from the date this all kicks in, any lease terms that talk about what tenants you're allowed in or not will be unenforceable, null and void. Insurance, there are certain insurance contracts that might have discriminatory terms in them at the moment, and if they are they will still continue to be relied upon when the Act comes into force. So this provision does not have retrospective effect, but any new insurance contracts that you take on in relation to your tenancy, those new terms will no longer be able to discriminate against children, families, and those on benefits. So if you're found to be discriminating on the basis of any of those things, you can be subject to financial penalties from the local authority. And again, the local authority are relying on tenants or prospective tenants from raising these issues and raising them and highlighting them. So you just need to be aware. But there is a clause in the bill which does state that a landlord can take the tenant's income into account. So it isn't that a landlord can't look at whether they can afford it. That is not true. They can under the new legislation. They just have to be careful as to how they apply that application. Being able to say, well, actually, you can't be a tenant because you can't afford the property. Look at your rental, look at your income. That's potentially not discriminatory. So you just need to be aware of what you're taking into account.
Yeah, so I will now discuss the Decent Home Standard and Awaab's law. So I'm not too sure if you guys are aware, but essentially, unfortunately, Awaab's law was introduced into the social housing sector first due to an infant sadly passing away because of the mould and dampness in a rental property, which is, really awful. So the government have decided to actually introduce this kind of Decent Home Standard by Awaab's law kind of into the rental private sector, which I would say is a really good move because tenants can't be suffering and what happens to that child is awful. So to give you kind of some statistics, so in 2022 and 2023, 21% of the private rented sector properties didn't actually meet the Decent Home Standard. So compare this with 10% of the social rented sector that didn't. So there's kind of 11% difference in that, which is quite huge. So yeah, I do think it needs to be brought in, and it will be brought in. So they have decided to do that. Now, the Decent Home Standard will be applicable to all tenancies. So this means that landlords will now have to ensure that their rented properties meet a set of standard, essentially. And this means that they'll have to deal with any kind of serious hazards in a timely manner. So yeah, so kind of the main things that you need to be aware of is that when this does become law, so it's unsure on whether this will be introduced kind of on the date that the bill becomes law, or it may be introduced kind of a bit after, as there's still kind of it's going through regulations and there's still debate around it, but it is going to be introduced. It's just a matter of when. But the main things that landlords need to be aware of is that it's going to be mandatory to have health and safety inspections, which need to be conducted regularly to address issues like dampness and mould. So landlords must also begin repairs for serious health hazards within 2 weeks. Tenants have a right to request independent inspections if the landlord is not addressing health and safety issues. These will be carried out by the local authority. And landlords who fail to comply with any requirements that may be needed to bring it up to the Decent Home Standard can actually face a final financial penalty of up to 7,000, face a prosecution, and potentially could be barred from renting altogether. So that's really, landlords really need to be hot on this and to make sure their properties are well looked after.
Okay, so I'm conscious that we're cantering through our time, so I'll try and cover these next bits quite swiftly. We're looking at the Chapter 2, the Landlord's Redress scheme. This is a brand new scheme that they're looking to bring in for prospective tenants, existing tenants, and former tenants. The believed is the intention to create an ombudsman to deal with landlords' complaints. Tenants' complaints about landlords. It's a mandatory membership. You can be prohibited from letting if you're not a member. So all landlords are going to have to sign up. Chances are there's going to be a fee, but we're not quite sure about the potential details. And if you don't become a member when you should, there's a potential fine of up to £7,000. So again, you really got to be hot on this. As soon as that scheme is released and we know what we're doing, get everyone on it. That's what we need to be doing. And there is a period of time in which you'll need to require to remain a member once a tenancy is finished to allow former tenants to still bring redress on issues. So you can't just end the tenancy and then leave the scheme. There will be a time where you're needed to be staying on. It's very tenant focused, and the intention is for the scheme that the awards are enforceable as if they're a court order. So if they make an award, it is binding. And on the screen, I've set out that landlords can be forced to issue an apology or an explanation, pay compensation, or cease or take action. So there's quite a lot that you can, as a landlord, be forced to do by the scheme. But it's not yet sure as to when it will come into play, because they've obviously got to sort out the scheme, make sure it's all usable, workable. So we're not quite sure whether it'll be phased introduction or as at one date. So watch this space on that one. Then the next bit is the private rented sector database. So you've got the redress scheme, which deals with tenant complaints, whereas this one is more seen as a kind of one-stop shop for tenants, or a front door, if you excuse the pun, of the property in this sector. So everyone has everything. You have an entry onto the database relating to the landlord, relating to the property. And it's also going to show whether there is any landlords on there who have received banning orders or convictions. So it shows all the naughty landlords, or they should put them, they call them rogue landlords, which is probably better. So you can see on the database, you can check your prospective landlord. So it gives tenants a bit of comfort as to who they're going to be dealing with, the type of properties they're going to be dealing with, and everything like that. So that's great. Increased transparency for tenants. And again, you have to have an entry on the database before you can get possession. So that again is what I went to before. It's a precondition of being able to get possession on Section 8. You need to be able to register, and you need to have your entry on that database. And if you don't, and the letting agent find that you've let out a property and it's not on the database, you can be subject to a fine. So that is something, again, which is going to come in, likely to be fees that you have to pay for each entry. Not sure how much they're going to be yet, or what scheme is going to be used. So we'll just have to wait and see in relation to this one and see what they bring in. But it's definitely something you need to be a member of. Compulsory registration for that one. So that kind of summarises, or in a very speedy manner, sorry about that, what is going to be brought in by the bill and the key changes. And one other thing that I've talked about all the way along is enforcement. They have tried to give the bill teeth by upping the local authorities' enforcement powers, and I would say incentivising tenants to report rogue landlords, to report abusive use of the possession grounds, because they've introduced new offences landlords can be found liable for, and also increased the remit of rent repayment orders. For those that don't know, a rent repayment order can be claimed by a tenant at the moment to seek to recover up to 12 months worth of rent back when offence has been committed. And normally these offences are relating to HMO licences not being obtained, etc. Well, these rent repayment orders will now become a lot more available for a lot more offences. So if you misuse a ground and you say your brother's going to occupy it, but your brother never does, then you need to be aware that you could then be subject to a rent repayment order claim from the tenants. And then also one thing that is really crucial that landlords need to be aware of is rent repayment orders. You can now claim up to 2 years worth of rent back as a tenant, not just 12 months. So that is quite a big jump. This is double what they can seek to come back. And it's to try and curb landlords' abusive use and to try and incentivise tenants to report. So it's to trying to get everyone to toe the line in the right sense. So that's kind of where enforcement is seeking to give the bill this teeth.
Yeah, and just following on from what Alice said, really. So, although kind of upon first reading, some of you might be pleased to hear that the bill doesn't make reference to gas safeties, EPCs, how to rent guides, it's very unlikely that those requirements, you know, have gone away. So yeah, provisions relating to these kind of requirements, which we need to deal with under Section 21, will most likely be added. But me and Alice believe it will kind of be added in relation to like compliance, you know, under the first, under when they enter into the tenancy on the database. So before possession can be awarded, they'll need to show they've kind of demonstrated and complied with the EPC, gas safety, how to rent, etc. But we'll wait for details on that.
So the big question of when.
Mm.
When is a good question. If I knew the answer, that would be great. They're talking about spring 2025, but the way they're going at the moment, they're rattling through it at a rate of knots to try and get it out. So I wouldn't be surprised if it came in earlier, but I think you need to start getting yourself in line and getting yourself in order now. How it's going to come in is still another kind of, the implementation provisions in the bill are quite complex and hard to decipher, but they have made it clear Labour wanted to come in on one date and to apply for everyone existing and new at the same time to avoid a confusing two-tier system. So you just need to be aware that when it comes in, it will apply, and it will apply to everything. So this is why we're now saying, what now? Now you have an idea of what changes are going to be made and how they might impact your properties. Now is the time to take time to assess and work out what you want to do. Do you want to keep the tenants in? Do you want to change your practices, make sure your tenancy agreements are up to date? Or do you want to get rid of any tenants you might deem problem tenants? Do you want to reassess, train new staff with your agents on how to deal with all this new legislation? And this is where we are here to help. This is what we've been gearing up to do. We are as up to date as we can with the legislation. We are here to help get you to where you want to be, whether that's still in the market when the bill comes in, or with new tenants in, or with problem tenants sorted out, systems in place, newer documents agreed. This is where we are able to help, and we can, now's the time to do it, basically.
Yeah, so following on from that, kind of where action is required to remove tenants in advance of the new regime, as Alice said, please don't leave it till the last minute, because I guess there'll be loads of people doing that, so it's just gonna be more tricky. And as kind of we go on, me and Alice are actually both finding more and more that before you can serve a Section 21, remedial action is needed. So you know, you need to kind of ensure that everything has been served, gas safety, how to rent, EPC, before you can actually serve a Section 21, to avoid, you know, just going to court and then getting kicked out by the judge because you haven't complied. We are also finding that the courts are finding ways to refuse to grant possession. I've done a couple of articles in recent months, but essentially two kind of key cases. There's one key case which highlighted that the signature on the gas safety certificate wasn't on there, so the gas engineer forgot to sign it. He put his name but forgot to sign the certificate, and then when they got to court, a judge actually held that didn't comply with the gas regulations, and so possession was not awarded. So that's just really something to be aware of, and you might want to go and review all your gas safety certificates to make sure they're signed. But it's particularly problematic because if you've had one done by an engineer that you no longer speak to, or you know, no longer can find, then the question is, what do you do about that? So yeah, so that kind of case law shed light on making sure they're signed. Again, deposit prescribed information is really something to be aware of. So usually we find that when we're reviewing tenancy agreements, the prescribed information is either at the back of the tenancy agreement, and it's usually sometimes given at the same time. But a recent case found that the deposit prescribed information needs to be given after receipt of a deposit and not before. So technically you can't give, a landlord can't give a tenancy agreement with the prescribed information first and then decide to take the deposit, because that will invalidate a Section 21 notice. the prescribed information needs to be given after the landlord is in receipt of that deposit. So that's really quite important. Another thing to kind of quickly point out is the terms and conditions of the scheme. So you've got My Deposits, TDS and DPS, which each have different sets of requirements. So it's really, really important that along with the prescribed information, landlords ensure that they're given the terms and conditions as set out in each scheme, because that can invalidate a Section 21 notice as well. These are all things that, you know, might not be glaringly obvious, but we kind of go through it on a day-to-day basis of remedying stuff. So it's just really important to kind of, if you do want to serve a Section 21, don't just go and do it, just seek advice from us or whoever's out there before doing it. Yeah.
Courts are being incredibly difficult in giving possession at the moment, and they seem to be able to find new ways to refuse granting possession. So we're keeping up to date with those to make sure that we can make sure everything's right at the beginning, so we don't then end up with a failed possession claim going. So that's the end of it. I hope you found it informative, albeit potentially a bit daunting with the new changes that are coming in. We're here to help, so do not hesitate to contact. I've had some questions asked, and I think I might be able to just go through a couple of them. With regards to Section 8 proceedings, ground 1A is the 12-month bar from the start date of the notice or the date of expiry. It's the start date of the notice. So the date you date your notice is the date the 12 months starts to begin with. So it's not when it expires, it's when you serve it. Could we use ground 6 for future MEES inquiries? I think potentially, if you can argue that you need to completely get the tenant out of the property in order to be able to comply with the upgrades for the MEES requirement, yes, you'd have to be able to evidence that you can't just do it room by room, for example. So yeah, potentially then you can do that. Does ground 6 extend to internal refurbishment or full-on development? Tim, I think that depends on what you're going to do.
Yeah.
The key is you need the tenants to move out for you to be able to do that.
Yeah, you can't, if they can stay in there whilst you're doing the works, that'd be an argument for the tenant to bring. And then, so you need to be able to demonstrate, like Alice said, that you simply can't carry out those works. Yeah.
Landlord's old deposit. Good question.
Yeah.
That's where we're a little bit confused as to what the legislation is specifically dealing with, whether it's the way they say you can give back the deposit or agree deductions suggests that if you haven't already done it, if you haven't already registered it, you're a bit too late. But I think that's going to become changed, because I think some people are going to highlight as it goes through that landlords are finding themselves in deadlock at the moment where tenants won't take back those deposits.
Yeah, it's really tricky.
So I think watch that space on that one. Oh, and where it's where the hazards, I think this question's been asked. How do landlords or agents stand with black condensation markings or mold caused by poor ventilation of a tenant? That will be dealt with by the Decent Home Standard and everything. But if you can evidence, and I think if you can investigate further and say that actually it's tenant use, then that potentially is going to alleviate the pressure on the landlord in which to take works if it's actually caused by the tenant. But again, we're going to have to see how the Decent Home Standard evolves as it's brought in to see how that then implies.
Yeah, and what you say, I mean, we deal with that now. It happens actually kind of now, where tenants are not ventilating the property, not using the dehumidifiers, and not, using sprays and stuff. And then the landlord's left with a property full of mold that through no fault of their own. So it is going to be difficult, and it'll be interesting to see, like Alice said, about the Decent Home Standard and then what happens. So I assume there'll be a lot more guidance on that and what landlords can do. Yeah.
So they're all the questions that we've been asked. So hopefully we've addressed those. If you have any other questions, please don't hesitate to email either of us, both of us, and we'll come back to you. If you've got any questions on reviewing your portfolio, what can you do, any specific questions, just contact us. We're here to help, and we're here to answer your questions.
Yeah.
So that's all we've got time for today. And thank you for staying on just that little bit over the hour. So thank you for that.
Thank you. Bye.